My name is Attorney Spencer Parr of Washington Law Center. At Washington Law Center, we represent hundreds of injured workers at any one time against the Department of Labor and Industries, against self-insured employers, and against other people that don't have injured workers' interests at heart. On June 30th, 2021, the Department of Labor and Industries started notifying injured workers' attorneys that a potential data breach had exposed or potentially exposed the injured workers' data to nefarious actors. Specifically, the department had contracted with a company called Pacific Market Research to conduct polling and data collection regarding the department's handling of injured workers' claims. It sounds like, oh, not a big deal, except that a specific statute within the Industrial Insurance Act specifies that the department is to hold injured workers' information, their claim file information, in confidentiality. The department turned over to its contracted polling vendor, contrary, we believe, to the purposes of that statute, certain data about more than 16,000 injured workers. That data included the injured worker's name, their address, their telephone number, their date of birth, and their employer's name, as well as the L&I claim number. Now, for those of us who work in the industry, the L&I claim number is a source of information just all by itself, because the coding of that L&I claim number tells us information about the claim, including whether or not it's against a self-insured employer or whether it's a state fund claim, as well as approximately when the claim was filed. We can derive lots of data just by the claim number. That is claim information. Under the revised Code of Washington, it is to be held by the department in confidence. Contrary to that RCW, they went out and gave it to a private market research company, and then, lo and behold, that company became subject to a ransomware attack. Well, the company notified the department. The department spent approximately 1 month not telling injured workers, coordinating with the public market research company, and devising a communication strategy before actually telling us what had happened. What are the ramifications for injured workers? Well, first of all, now they can't be assured that their claim information has been held in confidence. Now they have to worry about crimes of opportunity against injured workers, like identity theft. Now they have to have that much more stress in their claim, and ultimately they get to see a system that's kind of stacked against them, not really following the rules to the extent that it should. What does the Department of Labor and Industries use the data for? Well, as a 17-year workers' compensation attorney, here's how we see the data come back once it's collected. Specifically, the Department of Labor and Industries will share that data with researchers. Very often, those researchers have Masters of Public Health education and credentials. Those researchers that will then study the department's data, and they'll say, you know what, there's a correlation between the happiness or unhappiness of the injured worker and the length of the case, as well as how much benefit may have been achieved following certain types of interventions like an orthopedic surgery. The correlation will be placed out there, it will be published, here's all the data. Later on, unscrupulous IME physicians will testify that individual injured workers should not be allowed to have a particular surgery or procedure, or should have their claim closed, because you know what, when they examined the worker wasn't happy about how things had gone in their protracted claim. And that's just an indication that you're never going to satisfy them, you're never going to heal them, and if there's any kind of doubt as to whether or not they should have the next procedure, and those physicians will then certify that there's doubt. Well, if there's any doubt, the balance of consideration should weigh against, and what this can do is it can literally deprive injured workers. That's how this data ends up being used in practice. It can deprive injured workers of valuable claim rights. So on behalf of all injured workers in the state of Washington, we at Washington Law Center, knowing the process from the beginning to the end and how the data is taken in and then manipulated when it comes back out during our litigation processes, we are incensed because injured workers have a right to confidentiality. That confidentiality has to be held inviolate. Anybody who doesn't hold it inviolate, who is carefree, fancy-free with that data, that person needs to be out of the system. So at this point, I, Spencer Parr, co-founder of Washington Law Center, I am asking Governor Jay Inslee to demand the resignation of Director of Labor and Industries, Joel Sachs. If you go to Washington Law Center's webpage, you will find that there's a whole list of things that have been done under this particular director's handling and direction of the Department of Labor and Industries. There's a ton of things that we consider to be absolute scandals and abuses of injured workers' rights. Go learn about those. Think about the gravity of this kind of carefree handling of really, really important case information of our injured workers in this state. And then join me in the call to demand Director Joel Sachs resign, or if he won't resign, then it is time for Governor Jay Inslee to fire the Director of Labor and Industries. I'm Attorney Spencer Parr. If you need help in your labor and industries claim, please call Washington Law Center. Our attorneys can help. Thank you.